Okay, and I'm also going to share my screen and show our presentation today. So thank you for joining us. I'm Michelle Culnane. I'm the National Operations Manager for Medico-Legal Assessments Group, and I usually host these seminars and listen to our wonderful specialists talk about their areas of expertise. But we had quite a lot of people say, please, I'd like to know more about the Medical Negligence Triage Service. So I've asked my team member, Taylah McGregor, to join me. Taylah runs the triage service for me, if you like, and she is absolutely amazing and has become a key member of our team. So given that she runs it, I thought it'd be really important to involve her in this presentation, because those of you who are going to book these matters will deal with Taylah. So medical negligence, if you're watching this, you know what it is. And it is an absolutely, sadly, growing area of legal practice in Australia. So, pardon me, we established the triage service because of that growth in litigation and growth in inquiries. We also did it because the assessments and reports for these matters can be really, really labour intensive, complex, and they're distressing to the client or the injured person, regardless of whether the outcome of the report or the discussion is positive for their matter or not. The cost of these matters is higher than for doing a standard IME, not only because of the difficulty and complexity we spoke about, but also because of the increased risk of the specialist needing to give evidence in court, which is something we know that they don't like to do. Costs for these reports can also change. A standard IME tends to be the fixed price or whatever has been quoted, but sometimes these ones can change once the doctor starts looking at the material available and the complexity just increases, or the amount of research that they might need to do or consult with a colleague or what have you. So all of these things impact how these matters go along. An unfavourable report is not useful to the lawyer, and it can be really distressing to the client. Furthermore, many law firms don't have a disbursement funding option, and so the aggrieved person has to pay for this report themselves. So we looked at it and we went, if the injured person is having to pay for this themselves, and they're going to get a report that could be as much as 10,000 or even more, that absolutely annihilates their claim, why would they want to pay for that? Why would the lawyer want to receive that? And why does a doctor want to write that, knowing that it's not going to go anywhere? So we put the triage service in place to mitigate that, to save cost, to save time, and to be much more easy for the client to digest. So in the triage service, if it doesn't go to a report, you become the lawyer who went the extra mile for your client, rather than the lawyer who caused them to pay $10,000 on a negative report. So just wanted to share some images of the kinds of things that come across Taylah's desk all the time. So sometimes we sit and we look at these images and we just can't even believe it. So the things that we've observed by running the triage service, and particularly for states where the laws of discovery are more strict, is that if, as a result of a discussion with the specialist or even the initial triage, the opinion isn't going to make it a strong matter to carry forward, there's nothing in writing. There's nothing to be discovered. It's also a very fast response on the initial triage. We get greater engagement with the lawyers when we know that they're being able to engage with our specialists. Both our lawyers and our specialists tell us that they prefer to go this way. It is much easier. This process also makes it easier for the client, the injured person, to understand, and gives greater transparency to both the lawyer and the injured client. The lawyers can be more confident because the teleconference allows them to really get to know the specialist, to maybe even have a bit of a mini cross-examination to see how that specialist speaks and engages and how they think, which is going to inform them about the quality of the report. Also, if at the end of the teleconference, the matter isn't going to be a strong one to carry, the lawyer now is able to give better closure to their client as to why the matter isn't strong enough to carry on. Rather than just, I'm a lawyer and I don't think that this is good enough, they can say, hey, we've really talked to a great specialist, but it's just not a strong case. I'm so sorry. We've got to pay for the specialist time, but at least we're not paying for an expensive report. And of course, unless you're on the other side of the matter and you want an unfavourable report, you don't get one with our service. Now, before I hand over to Taylor, I'd just like to give you an example of one of the most negligent bits of medical work that I've ever seen. Does anyone recognise this woman? Jocelyn Wildenstein, who after a divorce and securing billions of dollars, decided to do some plastic surgery. And honestly, whoever did that to her really, yes, needs to go. So I'm going to hand over to Taylor. Now, if at any time anyone wants to ask a question, please interject and we'll answer your questions for you. So over to you, Taylor.
Perfect. Thank you, Michelle. So Michelle covered a lot of it really well, but guess I'm going to cover what we need from you from how I run the service day to day. So pretty much we receive your inquiry and a 2-page chronology of events. Pretty much what we need you to outline is the plaintiff, the defendant, and the alleged negligence. It'd help if you gave us a little bit more context that fits into the limitation of 2 pages. It is a free preliminary opinion. As it's free, we really can't ask the specialist to review 60 pages of documents for free. So we ask you to limit it to 2 pages, if you could please. So pretty much we then workshop it amongst ourselves and with a handful of specialists who they actually do really enjoy the service, which is great to hear that they enjoy their work, as do I. And we pretty much workshop it. We have a general surgeon, an orthopedic surgeon, an anaesthetist, and an emergency specialist, pain specialist, and plastic and reconstructive surgeon, who we all kind of really work closely together to get that free preliminary opinion for you. And based on their advice, we may approach further or different specialists. Sometimes they're a little bit more complex, these cases, than they originally pan out to be. We might think they need one specialist, but then it turns out that they actually need a different specialist to provide an opinion. After that, we get back to you, and usually it is within a day or so, and we pretty much just say, yep, there could be something. We should have a teleconference to discuss this further, or no, unfortunately, it's sad for the client, but there's no negligence and no case here.
These ones, just to interject, that we see these images all the time as well. And of course, currently in the public is the class action against people who have been the victim of the so-called cosmetic surgeons. And some of those are absolutely catastrophic. When we triage these ones, we're not only bringing in the type of surgeon who would normally have done that surgery, but we're also bringing in a scarring expert, somebody who can talk to the medications that this person might have, which can have down the track implications for stomach issues, headaches, nausea, interactions with other things, all because of one initial catastrophic surgery that has gone wrong. So there's an example for you. Okay, Tay.
Perfect. So again, just what we need from you is the 2-page summary chronology of events detailing the gender and age of the injured person and any pre-existing conditions, how the subject injury occurred, what is the reason you believe has been any negligence. That'd really help us if you could give as much detail as possible. It helps our specialists and our team, which is myself and Michelle, really just hone into that and get as much meat out of that as possible to get you the best free preliminary opinion as possible. Once we have a yes, there could be negligence opinion, then we will need the name of the specialist doctor involved and the hospital, if applicable, so that we can rule out any conflict of interest, which is a huge point that we pride ourselves on. We like to rule that out at the beginning so as to not waste valuable time and resources, not only from our team, but obviously of you as the client, so that we can rule out that conflict of interest right from the beginning and get you that right specialist that you need. Then we approach the chosen or relevant specialist and provide you with a quote for the teleconference. Again, we pride ourselves on that quote. We will never whack you with a fee. We always make sure to source a quote from the specialist, provide it to you. We will then get your approval agreement of the fee. And we get that all sorted. And once that's happened, you can then provide your letter of instruction and supporting documentation. We'll schedule the teleconference. And then once it goes ahead, only if you're satisfied with it, you can then go ahead and commission a report. And we always check in with you at every step of the way. It's never we leave you. We're always kind of guiding you or holding your hand, if you'd like to say that. And I always make sure to check in with how you're feeling with the service at every step of the way, whether you need another teleconference or whether you want to go to that report.
Awesome. So we thought we would share with you a couple of matters where this service has actually been of tremendous value. And in all honesty, there are endless numbers of them where, as Taylah and I progressed doing this, and I've been in this industry for many years, Taylah has been in with psychiatric matters for many years, but we've continued to learn so much, and it keeps on honing our skills in this area, and we keep seeing incredible results come out. Now, a major one was a paediatric matter where the child was born with a brain injury as a result of a complicated vaginal delivery in which the child suffered oxygen deprivation. Now, initially, the lawyer and the family wanted to sue the hospital for what had gone wrong in the labour ward. However, when we had a paediatrician who was also a geneticist have a look at this one, he started asking some questions based on some of the observations of the mother in the hospital and some of the prenatal treatment. Long story short, it turns out that this woman should have been offered prenatal genetic counselling and testing, which would have identified a genetic issue with that child, which would have indicated a scheduled caesarean birth from the get-go. And she could have been informed and known about that, and the child would not have been at risk and would not have suffered the subject brain injury. So that was an amazing catch, that one. Now, there was another orthopaedic matter where a GP in their practice performed an ingrown toenail procedure. It's something that's used to be done by GPs all the time, but would now more commonly be done by an orthopaedic surgeon or at best a podiatrist. But for some reason, this went ahead in the doctor's surgery. And the young person developed an osteomyelitis, which is an inflammation of the bone. The toe ended up having to be amputated. Now, what our orthopaedic surgeon identified was that the original procedure is what caused the osteomyelitis. And osteomyelitis is a really interesting and complex situation. We have to prove a breach to the bone barrier, to the bone membrane barrier, but we also have to prove the period of time when osteomyelitis can be detected on an MRI scan, which is between 12 and 13 days. And we had to do that from the date of the subject original surgery. So long story short, with all of the radiology and imaging, we were actually able to identify that it was that initial procedure that caused the osteomyelitis and resulted in the toe having to be amputated rather than any failure of the hospital care in relation to the infection. The next one was where a person had claimed post-surgical lethargy. And they claimed that they had had a surgery, a scheduled elective surgery, and that they'd been told that whilst they'd been under anaesthetic, they had a heart attack. They wanted to bring a claim against the hospital for not being given a cardiac assessment after the surgery, and also for not being counselled about the heart attack and what they should do, whether they should see their GP or anything like that. So our anaesthetist reviewed the surgical notes because the anaesthetist is the person who controls what's happening in an operation. The anaesthetist can call off a surgery at any time, and they can overrule the surgeon and order them to close up. They monitor the person's vital signs all the time. Now, our anaesthetist reviewed the surgical notes, pre and post-operative care, and identified that, in fact, the person had not had a heart attack. They had had a thing called laryngospasm. And a laryngospasm means simply that their larynx went into a rhythmical spasming, which compromises their airway, and then they need to be intubated with the metal device. And afterwards, they will often have a very sore throat. So the specialist will come to them afterwards, the anaesthetist will come to them and explain, and in this case, we saw that this did happen, explain to them that they had had laryngospasm in surgery, that this is a common complication of surgeries and it has no ongoing effect, but that the use of the intubating tube does cause a sore throat for a couple of days. And since they weren't expecting to wake up with a sore throat, that's why they get told about it. So in this instance, the person didn't have a claim. So these are just different examples of how we've saved it at either the free triage or the teleconference stage, and been able to give proper closure and save the matter. Now, we're experiencing a lot of these at the moment. I just thought I'd show you this. You may have heard of pelvic mesh. That's what it looks like in the hands of that surgeon there. Very harmful stuff. Harmless stuff by the look of it. However, what's been discovered with pelvic mesh is that when it gets inserted into the body, and particularly into the soft tissues of the bowel, the intestine, the lower abdomen, and the female reproductive tract, it merges into the tissues and it becomes almost like barbed wire. It's horrible, insidious stuff. And it can't be removed pretty much. There's a doctor in America who will attempt to remove it, and I think there's one in Australia who does it. What we see in slide B there is actually a piece of transvaginal mesh along with the attached tissue that's been removed, and that person has had to have major surgical reconstruction. So these are just some of the instances that we see, and we look at how we can best get the best report that's going to give the best outcome to you as lawyers in your matters. So what I'm going to do now is stop sharing my screen and throw it forward to any questions. Does anyone have anything they would like to ask us about our process or about a matter that you've got or anything like that? No questions? That's okay. Thank you very much for attending. Oh, we might have somebody there. Hang on. Bill? No? Okay. Look, thank you very much for attending the seminar. You will get the recording for this probably in a day or two. If you have any further questions, you can always contact myself or Taylor. Our email addresses are our first name dot initial of surname at Medico-Legal Assessments Group.com.au, and we can help you with triaging your matter and anything that you might need to know. So thank you very much for attending today, and have a great rest of the week. We look forward to seeing you at our future seminars. Thank you.
Thank you.